Habeas corpus is a phrase you've probably heard before. You maybe heard Sarah Koenig talk about it on Serial, or you've read the newspaper, and you know people who are in Guantanamo Bay file these things. Maybe you know it's how people try to get off death row. But what actually is it? What does it do? Since about 1305, prisoners have been filing writs of habeas corpus with their respective governments. Literally translated, habeas corpus is Latin for bring me the body, or you can have the body. And it's the primary way for someone who's in jail to say, hey government, you need to look at my case again because I shouldn't be here. Our Supreme Court has defined habeas corpus by saying, if the imprisonment can't be shown to conform with the fundamental requirements of law, then the prisoner is entitled to his immediate release. I want you to think about what that says. It doesn't say when someone's actually innocent, they're entitled to their immediate release. It says if their imprisonment doesn't conform with these fundamental requirements, then they're entitled to that immediate release. And that's what we're looking at today. We're going to look at the balance. On one hand, we have an interest in ensuring our society is safe and upholding the rules and prosecuting people who violate them. But on the other hand, we have an interest in protecting these rights, these fundamental rights that we've defined. I hope when you leave here today, you have a sense of what habeas corpus is. So when you sign a petition to free Stephen Avery or you read a newspaper article, you know what you're talking about. Habeas is a very complicated process. Lawyers spend their entire careers studying it. There's state and federal habeas proceedings. There's a lot of deadlines. And I think what's most interesting about it is if you're a prisoner, you're not entitled to an attorney. So as a result, a lot of the habeas petitions that go before the court look something like this. I think that's even more interesting when you think about who makes up our prison population. 41% of state and federal inmates haven't completed high school. And that number is even higher when you look just at the state system alone. 68% of state inmates haven't completed high school. So if you're sitting in this room today, you are probably more highly educated than the majority of these people filing petitions. Given that, I want you to put yourself in the shoes of one of these people, and we're going to walk through this process together. So, you're in jail, you don't think you should be there, you have this vague idea that you can do something about it, but what do you do next? I mentioned earlier you're not entitled to an attorney. What I didn't mention is that usually you're going to find somebody who's done this before who's in jail. So, you get lucky, you make the right friend. There's three basic things they're going to tell you. First of all, if you're going to file a habeas petition, it's got to be within 1 year of when your case became final. So if it's 20 years later and you decide you want to do this, you're going to be stopped from doing that. Second, you've got to exhaust all your other remedies. Today we don't really have time to get into what that fully means, but essentially a habeas petition is like a Hail Mary. It's your last chance. So you've got to make sure you've done everything else you possibly can before you file this. And then third, you only get one shot at this. There's federal law that prohibits you from filing second and successive petitions. So you've got to really make sure that you say exactly what you want to say the first time around. So let's say that you're successful and all three of those requirements are met. As an aside, 63% of the petitions filed in federal court are kicked out for one of those reasons. So that means in 63% of cases, the court's not even looking at what the prisoner is actually arguing about because of one of those problems. So this is Mr. Johnson. And we're going to put ourselves in the shoes of Mr. Johnson, and we're going to look at his case from his perspective, from the perspective of a police officer, from the perspective of the judge, and from a jury's perspective. Mr. Johnson is a fairly normal guy. He's in his mid-30s, he's in the Navy, he had no traumatic upbringing, no real abuse, no criminal history. He's been out at sea for a few weeks, and he comes in, he goes back to his apartment, and he's going about his business when a police officer shows up. So here's that police officer, Officer Harrison. Now he has been working in a Navy town for most of his career, and he really respects the military, but he also knows that sometimes when the ships come in, things get a little bit rowdy. So he's sitting at his desk and he gets a call. He shows up at the call and there's three guys there. There's a husband and then two neighbors. The husband's wife has been murdered. And so Officer Harrison has come and he starts asking questions. Now, Officer Harrison, like I said, he's been doing this for a long time. He has a pretty good sense of when people are lying to him. And he gets that sense with these two guys. He brings the two guys in for questioning, and these two guys end up confessing to committing the crime. Not only that, they say that they worked with Mr. Johnson. So, you're Mr. Johnson, you're brought in, and you're read your Miranda rights. Now, as you all know from watching Law & Order or Cops, you know that you're entitled to these things called Miranda rights. And that name comes from a case called Miranda versus Arizona, which essentially looked at these constitutional rights and said, when you're arrested, you have to be read these rights. One of those is the right to counsel, and that's protected by the Sixth Amendment. What that means is, when you're being questioned, you have a right to an attorney. And if you're not given one, and you're asked for one, and they keep questioning you, then that right has been violated. So, they start questioning Mr. Johnson, and Mr. Johnson tells them, I don't need an attorney, I'm okay. And they keep questioning him. They ask him if he'll submit to a polygraph examination. He says, sure. They ask him if he committed the murder. He said, no. And they come back and tell him that it shows that he's been lying. So a couple more hours of questions go by. Mr. Johnson is tired, he's stressed. And they keep telling him, you know, things will go a lot better for you if you confess as opposed to being found guilty at trial later. So Mr. Johnson finally says, I think I need an attorney here. And to which they say, no problem. But they keep asking questions. A couple more hours go by, and Mr. Johnson finally confesses to committing this crime. So now we're going to switch perspectives again, and look at this from the perspective of a jury member. Now, if you're a juror, you're not particularly excited to be there, especially a trial like this, which is going to go on for a couple weeks, and you see the prosecution put on their case, and there's no physical evidence tying this guy to the murder, but this guy confessed to doing it. And so if you confess to committing such a terrible crime, of course he's got to be guilty. So after the trial ends, you and a couple of the other jurors, you go and you deliberate, you come back and you find Mr. Johnson guilty. So back to being Mr. Johnson, you're sitting in jail knowing now you're going to spend the rest of your life there, and you start talking to some of your friends. And one message is clear. They keep saying, you know, it really sounds like you shouldn't have been questioned anymore once you asked for an attorney. This is where habeas comes into play. There's two different kinds of habeas. In one, you're claiming you're actually innocent. These are very difficult cases to prove. You've got to have some sort of new evidence that wasn't there at trial. So you can't just rehash the same details that came out before. The majority of habeas petitions that are filed are alleging that something was wrong. There was a constitutional violation. And that's what Mr. Johnson's going to do. So, this case goes before a judge. The judge looks at it. Now, judges look at a lot of these, and most of them are without merit, meaning the person's actually probably guilty, and there was no constitutional violation. But in this case, the judge sees what a terrible crime this person committed, but he also sees he wouldn't even know this person committed that crime without having his Sixth Amendment rights violated. As a result, a judge is going to grant this petition. What does that mean? All it means is that Mr. Johnson gets a new trial, and at that new trial, his confession won't be allowed in. In some ways, that seems like a very anticlimactic outcome. I'll tell you that Mr. Johnson's story is true, and in his real case, the prosecutors found out about this and dropped the charges against him, because with nothing tying him to the murder, they had no case to put on. So, was this the right outcome? Did Mr. Johnson actually do it? That's not really the question we're faced with in this habeas proceeding. What we're looking at is whether he was given the constitutional rights he was entitled to, and the answer here is no. For some of you, the outcome probably really bothers you, and others of you probably think that's really fair. There's very good arguments on both sides of that issue, and either way, what I want you to see is that there are two sides of this issue. I want you to understand it. The law is meant to be something created by us that shapes our values as a society. But if we don't know what the law is, we can't make it that. There's been a lot of studies done on Americans in the judiciary, and one message is really clear. We don't know much. 2/3 of Americans can't name one Supreme Court justice. 21% of Americans think that if the Supreme Court issues a 5-4 decision, It's going to go back to Congress, and then Congress will decide the issue. A third of Americans can't even name for you the 3 branches of government. So my challenge for all of us is to learn what we're talking about and then engage in the discussion. Because when we do that, we're able to form the law into what it was designed to be. So, thank you.